Boker tov lekulam. Guten Morgen. Welcome everybody. So now I exhausted all my Hebrew, but I see so many Israeli friends here and happy to welcome them in particular, and also our German and American friends. Well, thank you very much for the nice introduction. My name is Lars Hanson. I run the office of the Konrad Adenauer Foundation here, and I just wanted to start also with my thanks for this great cooperation we have here with the American University, working on this conference together, and I hope it's one step in a longer way we go together. Well, the Konrad Adenauer Foundation is a public policy organization that is close to the Christian Democratic Party in Germany, the party of Angela Merkel. We have something like 80 offices globally, including Germany, by the way. We do civic education in Germany. We have an office, as it was mentioned, in Jerusalem, where I had the privilege also to be posted. We have an office here in Washington, obviously, for North America, but many of these offices are in developing countries, and we promote values like freedom, democracy, social market economy, and the rule of law. Well, the foundation's name is obviously coming from the first chancellor in Germany after the Second World War, Konrad Adenauer. And Konrad Adenauer, one of the most important achievements of Konrad Adenauer was, first of all, to establish strong democracy in Germany, but also linking what was then western part of Germany to the West, in particular with very strong relations to the United States, strong transatlantic relationship. The other important thing, and this was mentioned here as well, Konrad Adenauer laid the foundation together with courageous politicians also from Israel, David Ben-Gurion. They laid the foundation for reconciliation and later also the establishment of the diplomatic relationship 1965. So, and with this heritage as Konrad Adenauer Foundation, this is also what is important for us, the transatlantic relationship, but also the relationship to Israel, the homeland of the Jewish people. And this is also brings us also to this conference. We want to discuss this triangle between Israel, United States, and Germany, and we want to, in particular, highlight the common foundation, the values which we share: freedom and responsibility of the individual, democracy, a market-oriented economy, and social responsibility. Of course, sometimes we interpret these values differently due to our different historic experiences, also different contexts we are living in. And this is what we will look into in this conference, how the common values translate into concrete policies in the different arenas that were mentioned already, in economic policies, also when it comes to the relationship between religion and state, but also in the justice area. Well, let me close on a rather personal note. I grew up in the eastern part of Germany, and this state then, the GDR, the socialist communist state, of course, had completely different values. And the personal freedom was clearly not among them. The United States helped us to bring down the wall, and I'm personally very happy and thankful to the United States, and it gives me a particular pleasure to be able to open a conference on shared values like freedom. And I also, as it was mentioned, I had later the chance to work and to live in Israel and to get to know this fantastic country. And since then, this triangle is also something that is very important for me personally. So therefore, I'm very pleased and honored to open this conference here in Washington. I would like to conclude also with thanks to my office, in particular Elmar Zurk, who is actually the backbone of this conference from our side. I'd like to thank him and the team of the Konrad Adenauer Foundation again, Professor Brenner and your team. Thank you very much. And by this, we open the conference and we start with the first panel. Thank you very much all for coming, and I wish all of us interesting discussions on this day. Thank you.
Thank you, Lars, and welcome to the session on courts as the guardians of the rule of law. It is a pleasure to have such a distinguished panelist, Chief Justice Dorit Beinisch, the former president of the Israeli Supreme Court, Judge Marian Blank-Horn of the United States Court of Appeal, and Professor Eckart, Klein of the University of Potsdam. My name is Salzberger. I'm a law professor and former dean of the Haifa University Faculty of Law and also the director of the Center for German and European Studies. The rule of law is the most important component for democratic success or for the good state. Its formal facet means that on the one hand, individuals enjoy full freedom to engage in any activity they are interested to pursue, save those activities explicitly prohibited by law. And on the other hand, governments and other unnatural legal persons are prohibited from any activities, save those that the law explicitly empowers them to engage with. Materialization of these two maxims denote that any human activity is governed by law. But such successful materialization depends on independent and impartial enforcement, the role of which is assigned to the judiciary. Without an independent judiciary, the formal facet of the rule of law cannot be achieved, as governments have tendencies to transgress their powers and violate individual rights. However, laws can delegate or empower governments and other authorities with draconic powers. They can also limit individual freedoms extensively by law. This is not only true for autocracies, but also for democratic regimes. Yes, it is the nature of office holders, also in democracies, to seek more powers. The rule of law, therefore, has also a substantive facet, which examines the constitutionality of restrictions on individual freedoms, on the one hand, and on the powers granted to the government and other authorities, on the other hand. Separation of powers, checks and balances, an entrenched Bill of Rights are some of the institutional building blocks designed to achieve this substantive facet of the rule of law. But again, without the effective enforcement, the chances to materialize substantive facet of the rule of law are slim. Constitutional courts, Supreme Courts, and the judiciary in general is entrusted with this key mission. Hence, the quality and independence of the judiciary is the most important condition for the rule of law for a democracy. The United States of America, the Federal Republic of Germany, and the State of Israel, despite significant structural differences in their structure of government, share various mutual political values. And in this session, we want to focus on the role of courts in these three countries in safeguarding the two facets of the rule of law, democratic values, and we want to also discuss common challenges that face judiciaries in the future. I think the case of Israel in this regard is particularly interesting. Unlike the US and Germany, Israel's governmental structure lacks key elements of separation of powers and checks and balances. We don't have federal structure. We don't have separation between the executive and the legislature. We have only one house of parliament. The only check and balance mechanism to the government power is the judiciary. For many political scientists, the fact that Israel 65 years had uninterrupted democracy is an enigma. In light of the fact that Israel has been in constant state of emergency since its existence, sometimes existential fear, that it is one of the few countries which is lacking a written constitution limiting the powers of government, in light of the fact that it inherited a non-democratic colonial legal regime system, and most of its founding fathers came from countries lacking democratic heritage or culture. Israel's democratic success is indeed surprising. How did Israel manage to, under these circumstances, manage to establish a liberal democracy, not without flaws? I think the key element to this enigma lies with Israel's legal establishment, primarily its judiciary, and especially the Supreme Court of Israel, which together with other legal institutions such as the Attorney General and the State Attorney Office, managed to construct and protect many features of democracy. The Israeli case indeed proves that a developed and independent judiciary is perhaps the most crucial condition for a successful democratic state, an insight which might have not characterized the American approach in promoting democracies around the world. The Israeli jurisprudence has many innovative features. Some are world precedents, but it also incorporated or imported key features from both the United States and the German jurisprudence. It is my pleasure and honor to invite Dorit Beinisch, the 9th president of the Israeli Supreme Court and the first woman to hold this key position, to elaborate on the Israeli experience as well as the challenges that are facing us. President Beinisch is a graduate of the Hebrew University of Jerusalem, where she also completed her LLM studies summa cum laude. She served 28 years at the Israeli Ministry of Justice in various positions as a deputy state attorney, a period in which I had the privilege to serve as her intern. She became then a public figure when she fought the Israeli prime minister and other top officials to reveal the truth and pursue legal action around the famous bus number 300 affair, an affair that could have been a basis for an episode in the House of Cards. In 1988, she was appointed to the first woman state attorney, and one of her memorable decisions during this period was her refusal to represent the Yitzhak Rabin government in a high court application against the deportation of 415 Hamas activists. In 1995, despite all these decisions, she was appointed to the Supreme Court, and this is also something that we can discuss later, the appointment mechanism to the courts, which in Israel, I think, we have one of the best systems. In 2006, after the retirement of Aharon Barak, she was appointed as the president of the court until her mandatory retirement in 2012. In her ruling, Beinisch emphasized the same principles that she fought for during her career as Attorney General in the Attorney General office, together with her approach regarding the role of the Supreme Court, with special attention to rights of human rights, civil rights, and special attention of rights of women and children. Socially vulnerable population and immigrant workers, a very top issue today in Israel. Beinisch emphasized the importance of judicial review of the executive branch, including the military, very different from the American approach, as well as the importance of following the rule of law and the principle of non-discriminatory law enforcement, and preserving every person's right to access the court. It will do injustice to single out some of her rulings. Nevertheless, I think that two of the most interesting rulings were her decision prohibiting absolutely any use of physical punishment by parents to their children, and the world precedent-setting ruling on the unconstitutional nature of the privatization of prisons. President Beinisch was awarded numerous reports and numerous prizes. You can see in her short biography that is attached to the conference program, and it's my pleasure and honor to invite her to give the key address of this panel.
Thank you. Professor Salzberger, for this introduction. You told the secret why you are not so objective about me already. And as to the first part of what you said, I really think if it was a judgment, I would just write that I agree. It doesn't have to, not the personal part, that I agree and I have nothing important to add. But I promised to say something here, so I'll do. I see it as a privilege to take part in this interesting exchange of views on the rule of law and the role of Supreme Courts. Today's discussion will allow us to explore this complex issue from the perspective of three legal systems, the USA, Germany, and Israel. I believe we all agree that the supremacy of law is the most important element in every democratic society. A lot has been said and written about what the meaning of the rule of law is. I accept the opinion that it means that every person and all branches of government are subject to the law, and actually you presented it already, Ellie. Today we'll speak about the three legal systems that have developed differently but share this basic conception of the rule of law. One could point out to several elements all three systems that we will discuss today have in common. First, the rule of law means the role of courts and the idea of judicial review is recognized and accepted, both by other branches of government and by the public. The practical implication of this acceptance is compliance with judgments and decisions rendered by the courts, even when disagreements arise. Such disagreements around specific judicial decisions are only natural in a healthy democracy. Substantive criticism is always welcome, as long as the legitimacy of the court and the binding nature of the decisions is respected. All three systems actively sustain judicial independence. The judiciary is an independent branch of government that is not subordinate to other branches. The procedures by which judges are appointed are designed to ensure that judges are not accountable or indebted to those whose actions they review. Finally, judges cannot be removed from the bench on the basis of content of their decisions or the way they understand and fulfill their duty. In all three systems, courts are the authoritative interpreters of the law. They are charged with the task of protecting human rights and the Constitution, and respect, of course, the separation of powers. The format of constitutional adjudication might be different, but the basic idea and purpose of judicial review are essentially the same. On the basis of this shared perception of the idea of the rule of law, each system developed its own constitutional structure and doctrines based upon its unique legal, social, cultural, and historical background. So allow me to introduce the way in which the idea of the rule of law is understood and implemented in the Israeli legal system, which is, of course, familiar to me much more than the two others, although we look to them and we are trying to learn from every system. I'll begin briefly reviewing the characteristics of Israel's legal system and what differentiates it from others. Unlike the US and Germany, Israel is not a federation. The layer of constitutional tensions regarding the delineation between federal and state jurisdiction, which are common in federal systems, is naturally absent from its constitutional law. Israel is a mixed legal system. It was initially based on common law, which we inherited from the British mandate that governed the territory, then Palestine, on which Israel was founded, but also preserved elements from continental and religious legal traditions. Modern Israel remains a common law system at its core, but we also developed an extensive corpus of legislation over time. The Supreme Court of Israel is the highest judicial instance in the country. It sits both as the final court of appeal in criminal and civil cases and administrative cases, and as the High Court of Justice, which hears constitutional and administrative petitions as a first and last instance court. When sitting as the High Court of Justice, the court performs functions of a constitutional court in the sense that it reviews legislation and actions of the executive branch. Lower courts in Israel must follow Supreme Court precedents. Lastly, Israel followed the common law tradition where it comes to the judicial role. Judges are appointed after having spent several years in the legal practice or in the academy, and they are not trained from the beginning, like I think in Germany or other systems. You have a special way to career judges. The judiciary is professional and apolitical. The rules regarding the appointment and service of judges are primarily set in a basic law. Judges are appointed by a special selection committee comprised of 9 members, including representatives from all 3 branches of government and the Israel Bar. Their appointment is in force until retirement at 70. A judge can only be removed from the bench by decision of the judges' selection committee passed with the support of at least 7 members of the committee, or by disciplinary action. Thanks God, we don't have these kind of cases. There are special provisions regarding the salary and benefits the judges receive. Israel emerged, as we all know, out of the trauma of World War II, and in particular, the horrors and atrocities the Jewish people suffered during the Holocaust. This was the background that led the founders of the state to base the Israeli Declaration of Independence around 2 defining principles: a commitment to establishing a home for the Jewish people, and a pledge to protect human rights and equality for all citizens. However, for decades, Israel lacked a formal written constitution. We inherited the traditional British notion of the supremacy of parliament, according to which primary legislation was immune to judicial review. Until 1992, human rights in Israel were largely the creation of the courts. Step by step, the Supreme Court recognized and developed political and civil rights and freedoms. In 1992, some basic rights were enshrined in 2 basic laws, which were later interpreted by Israel's Supreme Court as providing the courts with the power to review the constitutionality of primary legislation. This was Israel's Marbury versus Madison in a way. And so, Israel now has a partial constitution which has stirred major controversy. Criticism was and still is directed at the Supreme Court for allegedly overstepping its authority in interpreting the basic laws the way it did. In spite of the legislator has not acted to change this reality by amending the basic laws so as to revoke judicial review powers, even though it can technically do so with ease with any parliamentary regular majority, because our basic laws are not immune. This is to show that a consensus evolves surrounding the legitimacy of constitutional review in Israel, at least in principle. Our Supreme Court functions in a complex and diverse society. I don't think I have to elaborate. I think most of you know how complex and diverse is the Israeli society. Needless to stress that the court does not implement its own agenda, like every court, I think, shouldn't have an agenda. Besides protecting the rule of law and human rights. It protects values and constitutional rights widely agreed upon, the basic pillars of our legal and political system. The court jurisprudence is based on principles of justice and transparency, which have been part of Israel's common law for decades, as well as Israel's values as a Jewish and democratic state. Those values were enshrined in the basic laws regarding human rights, those 2 basic laws I mentioned. In our vibrant society, there is no consensus surrounding the content of those values, and the court is tasked with interpreting them. The court does not subscribe to any political view. It does not advance a particular economic order. It does not evaluate the wisdom or quality of piece of legislation or a certain government policy, only its compliance with the requirements of constitutional and administrative law. Thus, the court protects an extremely important fundamental social consensus. The protection of this consensus is not and should not be subject to the whims of a party that holds the reins of power at a given moment. The meaning of democracy is not only the rule of the majority. True democracy needs to uphold democratic values. In applying judicial review of legislative and administrative action, the court may only interfere if there is good reason to believe that the reviewed action infringes upon human rights or doesn't comply with the requirement of authority, reasonableness, proportionality, and due process, depending on the case, of course, at hand. This judicial restraint ensures that when the court does interfere, it is necessary to protect the rule of law and human rights. In spite of those elements of restraint, the Israeli Supreme Court is considered an activist court and very often criticized by some politicians for that reason. Without delving into discussing the meaning of judicial activism, this perception of the court is a result of the court's considerable willingness to apply judicial review over other branches of government and open the gates of the court to allow broad access to judicial remedy. In order to fulfill its role in a democratic society, the court needs to offer an effective, reliable address for those who seek justice. This is why I believe that the court ought to open its gates to petitioners and allow relatively broad access. With this, of course, we are very different than the American system. Standing requirements need to be liberal. If the rule of law is comprised, why should we compromise? Why should we insist that the case be brought before the court only by the injured party? In many cases, this requirement will prevent the case from ever reaching the court, especially when the injured parties are from the weaker groups in society and lack access to legal representation. This is why human rights groups and other NGOs advocating for the rule of law have standing in our court. Consider, for example, Israel's Supreme Court policy of hearing petitions of residents of the West Bank, and there was a time that we also heard petitions from the Gaza Strip in early times. Even during military activities, people came from Gaza and approached the court to review the military activity in their area. Israeli law does not extend to those territories. This policy offered remedy to residents of the territories whom are subject to a military regime that applies harsh restrictive measures. If the court had blocked their path to seek judicial review, they would be denied any chance of relief at all. The court's policy created a reality where the government and the military are subject to the rule of law and to the restrictions imposed by constitutional, international law, even when they operate beyond our borders. Also consider that some of the most important constitutional precedents set by Israel's Supreme Court were the result of petitions brought by public petitioners. To mention just a few, petitions submitted by Public Committee Against Torture in Israel resulted in 2 landmark decisions in the field of the fight against terrorism. In 1999, the Supreme Court prohibited the use of various investigations techniques involving physical pressure that were employed by the Israeli General Security Service against terrorists. In 2006, another petition submitted by the same group on the issue of the legality of targeted killings, a very hot issue now, the drones, so with us it was called targeted killings, in counterterrorism, it was decided. I think it's the only court that decided a case like that in our days. The court did not reject this practice altogether, but set guidelines for security forces to ensure that when it is used, it is necessary and proportionate and to protect as much as possible innocent people in the area. In 2010, the court decided a petition submitted by the Association for Civil Rights in Israel. The decision narrowed down governmental statutory authority, request private communications, also, I think, topic very well known here, private communication data for purposes of criminal or national security investigation. Those cases demonstrate the delicate balance between the public interest of security and protecting human rights. In a democracy, maximum security is not possible. The same is true for maximum protection of rights. Each comes at the expense of the other. The challenge before the court is often to strike the proper balance between the two based on the values of our democratic society. For the same reasons it opened its doors, the Supreme Court of Israel had avoided the dismissal of cases on the grounds of threshold arguments. The concepts of non-justiciability and its sub-requirements were narrowed down. Now, non-justiciability is, of course, a very important principle in the United States, as much as I know, not in Germany. The concepts of non-justiciability and its were narrowed down. Respect for other branches of government, albeit central and vital in a democratic system, cannot preclude judicial review in cases where the matter at hand involves a direct violation of human rights. Judicial review of military action in Israel is perhaps one of the best examples of the way the court's stance on justiciability contributed to protecting the rule of law. Of course, the court should always be mindful of its institutional position, of the nature of the issue before it. This is eventually a question of measure. Courts certainly cannot interfere every time, but they also cannot ignore flaws that amount to a breach of the basic principles of the rule of law in legislative or administrative acts. With that, I would like to offer some concluding thoughts, leading up to the discussion we will have. It is hard to say which system has better mechanisms in place. I can only comment that from the extent of judicial review in a given legal system ought to be derived from the context in which it had developed. Are the democratic foundations of society strong enough? What are the checks and balances? Are the legislature and the executive committed to human rights? What is right for one system might lead to poor results in another. For conclusion, courts around the world are ultimately confronted with similar issues as globalization takes its effect and societies change simultaneously. The problems of human rights and counterterrorism, all courts now in the Western world, if we can say Western world, deal with it. The right to privacy in an age of technology, equality and discrimination in the workplace, the rights of same-sex couples are only few of the matters brought before courts in the US, in Europe, and Israel alike. The challenges are therefore similar. So are the basic responsibility of courts as guardians of the rule of law. Those similarities make the exchange of views between representatives of different systems in which we will engage today and learning from the experience of other courts extremely important and useful. Wish we will all have a fruitful and interesting and productive discussion today.
Thank you very much, President Beinisch. We will now hear several comments from the two other triangle partners, the German and the American, and then open the floor for Q&A. Professor Eckart Klein is a former dean of the law faculty of the University of Potsdam. He also, in his past, served as a clerk at the Constitutional Court of Germany. He studied law in Freiburg, Göttingen, Lausanne, and Heidelberg. He was professor also at the University of Mainz, and currently he is the director of the Human Rights Center of the University of Potsdam. Professor Klein, please.
Thank you, Chair, and may I also take the opportunity to thank the organizers for having invited me to this very interesting conference. I would like to add a more theoretical aspect to this discussion. When we are looking around, we feel and see that we are surrounded with values everywhere. That is not astonishing at all, because after 2 world wars, the Holocaust, and the experience mankind has made with right-wing and left-wing dictatorships, of course, what else should be the fundament of our actions than values? It started immediately after the Second World War with the Charter of the United Nations. The maintenance of peace and protection of human rights were the main purposes of the world community, and only a few years later the Universal Declaration on Human Rights confirmed this approach. In 1949, the Statute of the Statute of the Council of Europe was created, and here we find a triad of values: democracy, rule of law, and human rights. And the last part, again, was taken up by the European Convention on Human Rights a year later. And Article 2 establishing, of the treaty establishing the European Union really ignites a firework of values. The provision maintains, and I quote, that the Union is founded on values of respect for human dignity, liberty, democracy, equality, rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to all member states in society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Everything what is beautiful and good is assembled here. And being a German, I cannot fail to quote, of course, Article 1 of the Basic Law, saying, human dignity shall be inviolable, to respect and protect it shall be the duty of all state authority. And Article 20 of the Basic Law, of course, contains the protection of democracy and the Rechtsstaat, which is not quite the same, but very similar to the rule of law. Now, having said this, we cannot neglect the fact that values always present problems. And I will give some examples for these problems. The first is that many different societies have different values. But even in societies which share the same values, there might be conflict about the correct and right interpretation of these values. I give you some examples. Take the right to life. Just in our 3 states and societies, we do not share the same approach regarding death penalty, biomedical problems, abortion, euthanasia. That is a problem. Right to life is everywhere recognized. And even also the rule of law. Justice Beinisch has already mentioned the controversy, the conflict that may arise between the right to privacy and the right to be safe, to be secured by state, to protect security. Or also, I just mentioned it, issues of social security, which also have something to do with values. And we have very different views on that, what we in Germany call Sozialstaat, to that what happens in other countries. Now, second, values have always the tendency to see other values as non-values. Values claim to be true and therefore absolute. They are hostile to compromises. And it's not by chance that one German philosopher has even spoken of the tyranny of values. Therefore, we have to tame values. And speaking as a lawyer, we can tame values only if we translate them into legal norms, which makes them accessible for interpretation and apt, particularly to become apt to get balanced with each other. This brings me to the third problem, and the last here in this context. It's possible that values are conflicting with each other. We could solve these problems if we would accept a hierarchy of values. I quite often was occupied with this problem, but I don't think that there is a hierarchy of values, because this would be very dangerous, because very rarely only one can say a priori that one value in a certain individual case should prevail over another value or over another right in which the value is contained. So perhaps with the exception of human dignity, at least according to the German doctrine, and as I have read out, the human dignity is the highest worth, the highest value in the German legal order. All the other values cannot take from the beginning precedence over other values. They must be balanced in each and every individual case. Now, how can these values or these values contained in legal rules be translated into society or into policies of the state? Of course, human rights are subjective rights and may therefore be invoked by individuals and brought before the courts because they are directly applicable. But the Federal Constitutional Court, the court at the top of the judiciary in Germany, has held that the individual rights, the basic rights, are not only subjective rights, but they form an objective order of values, an objective order of values. And values are tending to extend everywhere, and therefore also this objective legal order of values is necessarily influencing all parts of law, be it criminal law, public law, and even private law. And this is likewise true for the organization of the state. The state institutions must be so organized that they are able to implement these values by their structure. And for the judiciary, of course, that means what all my predecessors have already said, the courts must be independent and impartial to be able to fulfill effectively this work. And another important instrument to translate the values into society could be something that one has called the Drittwirkung of human rights or of basic rights. That means saying that basic rights have an horizontal effect, that they do not only entitle individuals, but also at the same time obligate individuals. Our Federal Constitutional Court has not accepted this horizontal view of basic rights, with very few exceptions I will not deal with here. But usually individual rights, constitutional rights, are only directed against the state and not against individuals. So individuals are not obliged directly to adopt to make use of these rights in the communication with each other. No, but the Federal Constitutional Court says that the state has an obligation to protect the values contained in these basic rights. And therefore the state has the obligation to enact laws that protect these values of the individuals against other individuals. If there is a gap, if this protection is not fulfilled, then is not performed, then the court would strike down this law and declare it unconstitutional and void. The last part is not now what are the challenges for the German judiciary in order to defend these values. Now, always when a constitution establishes a court, in our case the Federal Constitutional Court and the other land constitutional courts, as a guardian of the Constitution and of the values contained in the Constitution, then, of course, controversies between the court and particularly the parliament, the legislature, may arise. And this is a permanent problem, and I think this have all those states which have established a judiciary able to judge the statutes of the state. I just wish to add that the Federal Constitutional Court does not know a maxim as the Supreme Court here in the United States. He does not know a political question doctrine. So all internationally relevant acts like treaties or unilateral international acts may come under the scrutiny of the Federal Constitutional Court. And this, just in our times, is particularly interesting for the European integration. I come back in my last point to this. There's another example showing that there are problems of conflicting values, even if these values are identical. For example, protection of life. In the aftermath of 9/11, the German legislature enacted a law, the Air Security Act. And this statute allowed the executive or the German Air Force to shoot down an aircraft that had been hijacked or that would be used by terrorists to perform a terrorist act. Of course, everything comes before the Federal Constitutional Court in Germany, and this act too. And the Federal Court declared this law, or at least this concrete provision, unconstitutional and void. arguing that not only the lives of the innocent passengers in the airplane would be at stake, but also that their human dignity would be violated. And human dignity, as I said, is the highest value, and so, having said this, the court was really unable to balance the struggle against terrorism against the lives of innocent people on the earth. So you see that one may welcome this clear support for human dignity, of course, but it's evident that this assessment opens a serious security gap, which also, and even the Federal Constitutional Court itself has acknowledged. It is a serious security gap that cannot be closed, because human dignity is the highest value, and so we are helpless in situations like this. And then another challenge is closely connected with the fact that the Germany's legal order is part of a multi-level system of values, national, regional, universal. In these situations, problems may arise less from the legal guarantees in the different documents, but particularly from different interpretations of those rights by the different courts. The Federal Constitutional Court, the European Court for Human Rights, and the European Court of Justice in Luxembourg, the court of the EU. Until now, there has not been a real clash between these jurisdictions, but theoretically it may come out any day, every day. The court has tried to, the Federal Constitutional Court has tried to avoid it by taking into account the jurisprudence of these European courts in interpreting the rule of law, and particularly the human rights, the basic rights of the Constitution. But there is a limit. If that interpretation of these courts could not become made compatible, could not be understood in the sense of the basic law, then the Federal Constitutional Court would go along what the basic law is saying and not accepting what the other courts are saying. Now, in conclusion, first, values are difficult to handle. Second, seen from a lawyer's point of view, it's important to transfer them into legal norms which are able to govern the whole legal order. And third, the system will only work if the creation of the rules is assigned to a body which is prepared to legislate in the sense of the underlying values, and where an independent judiciary exists fulfilling the task of interpreting and, if necessary, balancing these rights. Thank you very much for your attention.
Thank you very much, Professor Klein. And our third panelist is Judge Marian Blackhorn, who was appointed to the United States Court of Federal Claim by the President in 1986. She is a graduate of Bernard College, Columbia University, and received her JD degree from the Fordham University School of Law. Before being appointed to the United States Court of Federal Claim, Judge Horn served as acting solicitor and principal deputy solicitor at the United States Department of the Interior. Judge Horn is also an adjunct professor at the George Washington University School of Law and at the Washington College of Law at American University. Judge Horn, please.
Thank you. It is also my pleasure to be here today, and I very much appreciate the distinguished colleagues that I'm sharing the panel with. I've done a number of programs for the Konrad Adenauer Stiftung before, And one of the things that is quite obvious in that respect is how, for the three countries represented at this table, it's a very easy conversation that we're going to have today. One of the projects I did for the Adenauer Stiftung before was to deal with chief judges from Southern Africa. And it was a marvelous program, but we weren't talking the same language. And I'm not talking about English, German, and Hebrew. I'm talking about we were not coming from the same place. And one of the biggest aspects of that was the aspect of transparency. Not only must the courts embody the values that we have, but there has to be a transparent court process. And when we talk to, for example, I've done programs, I do a fair amount of rule of law work, and when we talk to Chinese on government contracting, that was a very different conversation as well. So here today, we're sharing a basic history in many ways, implemented differently perhaps, but a Judeo-Christian tradition that really formulates a lot of the values that were just spoken about that embody each of our three court systems. So starting with that, I think it's much more difficult actually to find the differences and very, very easy to find the common issues in our heritage. We do business together, the three countries, and we know how to do that. We have expectations amongst the three countries embodied by our judicial systems, but also a reliance on those judicial systems to embody the future work economically between the countries. There's a reliance that the courts will, in fact, enforce those basic common values. So when you're starting, for example, going back to a project I did for the Trust Territories of the Pacific when the United States gave up that territorial relationship, when I was at the Department of Interior, we set up court systems in those countries, but we also had to incorporate the tribal talking heads who were an intimate part of the legal system in the localities. Similarly, I've done some projects that involve some of the Middle Eastern countries, and there again, we have to be very cognizant that certain aspects of society are embodied in Sharia and that you simply have to deal with that. To help those countries have more transparent projects. One of those projects, in fact, was a project sent over by the King of Morocco to figure out how to make the Moroccan judicial system more transparent. Some of you say, well, that's an oxymoron. It really isn't. But it was a very different kind of challenging couple of days there. In our case, it's nuances we're talking about. Some very basic nuances, and most of those derive from our individual histories and also from our political systems as we have it now. Our Supreme Court derives from Article 3 of our Constitution, as well as all the other federal courts. And in that regard, I have to make a minor correction. I'm actually in the trenches. It's where I want to be. I'm not on an appeals court. I'm on a trial court. And that's another interesting aspect. We represent our distinguished colleague from Israel, who's the pinnacle. I'm down in the deep trenches. And I deal with the everyday problems, and I deal with implementing what the Supreme Court does. And that's also one of the very interesting aspects of what we have to do. When the Supreme Court makes a ruling, as they have in one of our big economic sectors, for example, in the banking world, I looked at that opinion, and with all due respect, I'm sure this never happens in Israel, but I found it almost impossible to understand the opinion. It was a plurality opinion in which you literally had to make a chart to figure out what each of the justice conglomerations did. So you had 4 here and 5 there and 3 there on different issues. And yet it was 110 of billion-dollar cases in our court that we had to deal with. These are the famous Winstar cases. Very difficult to implement. So the range is probably well represented on this bench, but on a day-to-day basis, of course, we're all dealing with the same thing. Now, it was said earlier that the Israeli Supreme Court describes itself as an activist court. Here, that is a major issue. Should it be an activist court, or should it be a court that simply interprets the Constitution, even going back to the Federalist Papers, which were written at the time the Constitution was written, or maybe even a little earlier, or should the courts embody a very quickly changing society and actually implement some of the more modern social trends? You have a tremendous split. You have people on all sides of that issue at every level of the court system. And that becomes a more difficult debate in our country also because, in fact, we are politically appointed in the federal court system. I'd like to say it was all my talent and good looks that got me to the court, but I know it wasn't. I happened to be blessed with a political husband, so I could actually concentrate on the law. But it does translate down all the way through the trial courts to a very, very serious debate. So if you have judges who are appointed currently under the Obama administration, they're going to be, as a rule, different from the judges appointed under the Bush-Reagan administrations. Now, sometimes you get surprises. We've had historical surprises over the years. Our Chief Justice, Earl Warren, for example, is the best example of that probably, where he was appointed by a Republican president and turned out to be one of the leaders in liberal changes on the court. So some of this is less predictable as well. We don't necessarily know our judges as well when they rise to any level of the court system or, in fact, to the Supreme Court, because so much of the element of getting there is a talented individual, no doubt, but also one with political aspirations and connections. Somebody like my colleague on the right to me had a long history of going through a preparatory system. On the left to me, it's actually a career. My father actually was a Landgerichtsrat in Germany, so I've studied that system. I have connections to both these countries, both in terms of family living in Israel and many long history in Germany. So this was a really interesting project for me, particularly because it forced me to look at some of the things that really are the differences and the similarities. If we look at the values, the constitutional protection of life, liberty, and property are common to all. Respect for the rule of law, access to the courts, an independent judiciary, right to fair trial, transparency in the court system, equality under the law, emphasis on individual rights, right to participate in the democracy by a freely elected representatives, and then the right to oversight in the courts, right to privacy, in our case, separation of powers. And many of these things really are all the same. I don't think any one of the countries would disagree that these are the underpinnings of where we come from and what is the sort of value system that is embodied in our court system. At the same time, we have some serious differences based on these very common values. Difference of the role of the judge, for example. In the trial courts, the judge is supposed to be a relatively neutral player, keeping an adversarial system fair, just, and balanced. That's not necessarily true in some of the other countries that are represented at this table. Difference in the use of juries. There is no jury right in many instances. In our cases, both criminal and civil, there is a jury right. And it's the right of the defendant. But there's also a trial only by a judge if opted for by the party. So very different right there. The right to a lawyer, very different. In this country, there is a right, absolute right, constitutionally derived right to a lawyer in criminal cases, but not in civil. And that is a big difference to some other countries. For example, Germany, I know for a fact that that is a right that's there. We have a system of semi-support. We have legal aid societies. We have criminal justice act lawyers in the criminal side, but that's because you're guaranteed a right, not only from the public defender, but from some appointment process. But on the civil side, not at all. In fact, we get requests by civil plaintiffs all the time for an appointed counsel, and we do not honor them necessarily. Some of the ones that I've seen most recently have been from our quote-unquote pro se, not necessarily such balanced individuals who find the courts on an internet and just send 20 applications to all the courts they can possibly type out an envelope to. But there are some more serious ones, obviously, where in a civil case we do not guarantee a right to an attorney. What is considered criminal is obviously different in all the countries, even though we share common values. An insult is not considered criminal in our country. It can be in Germany, for example. How you become a judge is different. In our country, it is federally appointed, presidential appointment, confirmation by the Senate, one of the most difficult and torturous process that anybody will go through. I've done it twice. It is not fun. But fortunately, there was a good end result. But it involves things that have very little to do with your professionalism. And in one case, I was a public official. I was the acting solicitor of the Department of Interior, the senior-most lawyer at the Department of Interior. And it was all about the policies that the secretary had initiated that I had never even touched. But they were mine for the purposes of confirmation. And so how you become a judge. Now, we also have state court judges who are elected, which is another phenomenon that many of us, both in the United States as well as abroad, find appalling. And one of our former, retired Supreme Court justices, Justice Sandra Day O'Connor, who I had the privilege to be sworn in by both times, is actively out there trying to campaign against that. But we do have a lot of our judges all through the state system elected. The role of religion as it's enacted in through the courts is also very different. Does it play a role? Does it not play a role? Strictly speaking, there's a separation of powers here in this country. It goes to a greater or lesser extent in some other countries that share our values. Death penalty was mentioned. That's obviously a big difference for the United States. Plea bargaining in criminal cases, as well as settlement negotiations in civil cases. The settlement in civil is probably worldwide and is becoming more and more utilized even in developing countries at this point. But in criminal cases, we have a massive amount of cases that are plea bargained away, and that's not typical in some other countries as well. Our system would probably break down if we didn't use plea bargains at this point, just in terms of volume. Rules of evidence. We have a very convoluted, if you're not a lawyer, set of rules of evidence that allow you to use certain types of evidence or not. For the big example is our hearsay rule. When I teach to LLM students who are coming from many different countries, both developed and underdeveloped countries, or developing, I should say, countries, they're horrified by our rules of evidence. And we sometimes let them audit our evidence classes because there's no way that even in a semester they can figure out some of these really inwards and outwards kind of backwards rules. But it is a big difference. Our implementation of the laws on firearms, again, it shared values, different implementation. Search and seizure, Miranda warnings, the types of protections that we put on criminal cases, implementation, different. Personal liberty is the shared common value here. But the biggest one probably is how we affect constitutional changes that then obviously impact the laws at the Supreme Court level. In our case, it's very difficult to affect a constitutional change. It's not just a statutory change. It's an amendment process that has to go through elaborate votes in the states, and it's a slow process. And that's probably why the debate that we have on activist judges or non-activist judges is so intense, because it can't be done just by a constitutional amendment. And so, of course, we change things. If you think to yourself that the internet is 25 years old And society has, or roughly 25 years old, and society has been impacted hugely by that. Everything, including privacy, obviously needs some recognition by the courts that the world is different than it was 25 years ago. That's not the only area of law that's true, but it's a pretty flagrant example. So the lower courts and the appellate courts and the Supreme Court in their own way do make some changes, but it's a much slower process. We cannot simply do a legislative change. And that's probably assisted in our case by the federalism system, where things can happen in the states, and if not challenged, obviously the change occurs. But on the big things like gay rights, which is the most recent big debate, the Supreme Court having affected change, it does have to work its way up through the entire court system. So we move slowly, even though we move fast as a society. We move slowly in the legal system. And it's obvious that although we start at the same place, Israel, Germany, the United States, many other countries, we end up at very different places for the reasons of how we implement that change. Thank you.
Judge Horn. Due to the weather, we have limited time for questions, so please be socially responsible and be concise, please.
Good morning. Thank you for your presentations. Thank you for putting this together to the two sponsors. Just a couple of questions. Could you talk a little bit about the theory of the unitary executive as it may apply in each of your countries? It's kind of interesting how that might. Oh, thanks. Thank you. If you could talk a little bit about the theory of the unitary executive as it applies to each of your countries, or as it may not apply. This is something that has been of interest here for the last 10 years or so, or 15 years, and going further back as well. And then the other question I had was, you kind of touched on it a little bit, Justice Beinisch, with regard to the use of appellate courts in determining disproportionality. Could you talk a little bit more about that, when you might, for example, I don't know whether this is the case in Israel, but at least here, sometimes an appellate court will cut back on civil damages, for example, from a $23 million judgment at the trial level to a $5 million judgment at the appellate level. So if you could talk a little bit about why appellate courts do that, what's the rationale, what do you mean by disproportionality? Thank you.
I don't know. I mean, I'm not sure I understood your first question about unity administration or executive. What is the essence that bothers you on that?
Well, it's the nature of an executive.
Yes.
Having certain capacities that are inherent that exist because of that person being the executive. Kind of like if the president does it, it's not illegal kind of mentality. Applying it perhaps in a parliamentary system in Israel, where the prime minister or the cabinet is essentially functioning as an executive.
This is true that in our system, not like the American, the power of the executive could be reviewed by the courts, could be, I mean, it's not only accountable as the executive to the parliament, but it is also reviewable by the courts. And I think that the powers in the president, as much as I can see in the American system, are much more, if I say, immune from judicial review than in our system. So it's true that the prime minister, and they have a very, very wide authority, but we may, if it's not a political issue, but from the legal point of view, from the legal aspects, we may review if it's reasonableness of a decision, of every act, the proportionality. This is where the proportionality rule we use. I think it's very similar to the proportionality, if I'm not mistaken, in the German system and international law. This is not only an Israeli tool to review the acts of government through proportionality. The cases that you mentioned is different. I mean, in private law, we have different, we can assess it. We don't need a proportionality rule to see if a kind of compensation is exaggerated, because we have our rule to assess the compensation. And if sometimes someone, it's not a jury that decides, it's a judge, which is very different if it's a judge. And then we have the rules how to assess the damage and the compensation. And this is I think this is a part which is legally professional in the private sphere of law. So we don't give such exaggerated sums of money as compensation. I think it's proportionate, but we don't need a proportionality rule to assess it.
Maybe I should insert some more provocation to the question and then turn to Judge Horn. I think that the U.S. case is very different from the Israeli and the German case in the sense that ever since President Lincoln, presidents actually claim to have prerogative powers that are not basically given to them in the Constitution in any law. And the courts have not managed to curtail or to limit. They didn't want to intervene. This is something that doesn't happen both in Israel and Germany, but maybe Judge Hall can correct me.
I think there is a false premise in your question, actually. We have I'm not sure I understood the word you used, but just to outline the system here a little bit, we have separation of powers, which is the big thing that underlines all of this. So the legislature enacts the statutory framework, and the executive branch implements it. That includes the president. The president has certain powers, like war powers, and a limited number of powers that are less overseen by the legislature. But essentially everything the executive does is subject to legislative oversight and then to judicial oversight. The laws that are enacted and the statutes can be challenged in the courts, either under Administrative Procedure Act review or under other ways in which cases come up to the courts. The debate that's going on now, which is maybe what you're referring to, is that this president is using executive orders for the first time in a broader way than some previous presidents have done. But it is not unchallengeable, and it can go through the courts. So I'm not sure there is a imperious president who could get away with absolutely anything. And of course, the president can be theoretically impeached. I'm not sure that would be very good for this country, nor was it necessarily an easy time for this country when there was an impeachment process in this country for President Clinton, albeit not on something he did as an executive. But it is not a system in which the president can willy-nilly do what he or she wants.
If you may, I want to add something. It has to do, I think all three systems have a separation of powers, of course. This is part of the construction of our democracy. But it has to do with a political, as you already mentioned, a political question which is not touched by the American courts, and depends how you define this and to defer so much. This is different because the American courts differ very much when it has to do with military decisions and the president decisions or orders. They would differ respecting the separation of powers in a way. And this is not the same of course, in our system where we don't differ so much because we think that everything could be reviewed if we have a legal cause, of course, and not a political action.
There's a case called Euler v. Willoughby, which is the one that differs in military situations, and but it's not absolute by any means. It is a deference as opposed to an absolute refusal to get involved. On the other side, with political questions, as you can see. And there was a great debate in this country when Bush v. Gore came up through the Supreme Court. They found a way to deal with the problem as a non-political question. So it's all in the interpretation again.
Matter of interpretation.
Yes, please. Okay, we'll collect several questions.
Let me pursue this. Oh, Stanley Kober. Let me pursue this, because the courts on these military issues are refusing to judge. For example, the Alaki decision. The court just refused to make a decision, political question. Now, let's go back to Nuremberg, or the American case of Little against Bareem. You're a military officer. You think the order isn't legal. If the courts then refuse to make a decision, you are hung out to dry. What do you do then?
Thank you. Just a quick question regarding, my name is Yara, I'm from Israel. A quick question about the last law that was just approved about the blockade percentage that was raised from 2% to 25% in Israel, and it's changing also the number of the representatives in Israel for new parties, about checks and balances, and how do you compare it to the other systems, Israel, Germany, where the percentage is 5%, and America, where it's not really relevant for this system. Thank you.
I'm Ruth Levouche from the Law Library of Congress, and my question is directed especially to Professor Klein. You spoke about the balancing of or a hierarchy of values, and you mentioned a case in Germany whereby a law that would have permitted shooting an aircraft that is suspected of being involved in a terrorism action could not be upheld because it violated the right to dignity. Now, both in Israel and in the and in Germany, the terminology of dignity exists. It does not exist under U.S. law, as far as I know. I mean, in the Constitution, the word dignity is not there, and there are those in this country.
Happiness.
Yeah.
Dignity is pursuit of happiness. This is my question. Do the Germans define what dignity is?
Last two questions, please. Yes, sir.
Hold on.
Michael Kurzig, whose father practiced law in Berlin until July 1933, when his right to practice law was removed because he was not of Aryan stock. And I have a very nice letter testifying to that. I want to bring it to the current situation in Europe. And that is the problem that I see as a demographic invasion of Europe by Islam. And you have the introduction of Sharia courts in England. And you've got pressures of population, somewhat in Germany, now in Belgium, now in Denmark, where half the children are named Muhammad. How do you see the future of the law that we believe in, of freedom, all the freedoms that we believe in, number one? And for the judge here, we've got the challenges in this country now, in a number of states, to introduce Sharia law into courts in the United States. And there's been a number of state legislatures that have now banned it completely. I mean, I believe our Constitution is good enough. We don't need that. And I wonder what your comment is on that. Thank you very much.
Thank you.
I'm not a lawyer. I'm not related to a lawyer, but my question is, it goes different. It's kind of future-looking. We assembled to find out the similarities in the law across the societies, and you all mention human rights and dignity and so forth as the commonality, and yet you all agree that in your respective societies, the meaning of each of these words differs. So, there's an old idea that the controversy, does the folk ways make state ways, or do state ways make folk ways? And it always seems to me that the law develops organically based on the society and the culture. So where are we going? there's this pressure in the legal profession, it seems, to try to have a commonality, a universal approach. But yet, folkways make state ways. Where do you see us going?
Thank you. Professor Eckart, please.
Well, what is dignity? There, of course, the basic law mentions human dignity, but it doesn't define it. That has been left to the judiciary, particularly to the Federal Constitutional Court. And the Federal Constitutional Court has interpreted human dignity on the basis of what the philosopher Kant has said. And he said that dignity has no price but a value. From this, for example, the autonomy of the person, where the autonomy of the person, of the personal mind, can be upheld. So torture is destroying the personal autonomy. That is probably the best and most convincing example for a violation of human dignity. And if the basic law says that human dignity is inviolable, then of course it does not say it cannot be violated, but it must not be violated. And persons may never lose their inherent human dignity, even if the respect for human dignity has been violated. That is, there are a lot of different interpretations, but that is what the Federal Constitutional Court is saying. If you take this airplane case, Air Security Act, then this decision was really disputed among, well, the public, within the public, because not only because of the gap I spoke about, the security gap, which was opened by this decision, but because people said, and I have to say I belong to them, that in this case, human dignity is not involved. It's, of course, life is involved of the innocent passengers, but why should their human dignity be involved? Or why should not, on the other side, the human dignity be involved of the human beings on the ground? So then we would have this conflict between human dignity and human dignity, and that is the supreme value, and you cannot solve it by a hierarchy. So I think one should be very careful to adopt and to use in practice this human dignity, because it takes you out of any possibility to balance. And that, I think, is always, it's not a good approach to legal problems. Well, I think our societies, and particularly the law, but not only the law, is under pressure with regard to demographic and climate changes too. And if you think of the public is hesitant or even denies the possibility for the politicians to adopt refugees, for example. But here we have really to act. The public international law, as it stands now, does not really protect refugees that come from countries to flee demographic or climate changes. Now there is a discussion to enact or to conclude another treaty on refugees, particularly for climate refugees. But this is not yet. There is not yet a consensus about this. So we will have to accept these people, who are in the danger of life, just to keep them and to help them, and then perhaps if the situation in their country improves, to send them back or to keep them. I think we cannot lower the human rights standard which we have arrived at, and it must be made so in this way, made up in this way that we can meet these challenges. I don't see any other way out of the trouble.
Thank you, Judge Horn. Very briefly.
Let me start by just saying differences are not necessarily bad, which is, I think, part of the premise that the question was coming from. And I'm not suggesting that Sharia is going to become part of our law. I don't think it is. I think it's going to be a very long day before that becomes incorporated in our legal system. But the fact that we, 3 countries, for example, have implemented differences starting with the same values is in response to the needs of each of the individual societies and to the fact that we are democratic societies and therefore can enact the laws that the majority of the people through their elected representatives choose to go with. So I think we just have to work with the differences, accept them, and move forward. I don't think the fact that the American system doesn't use the word dignity makes it any less of a system which respects dignity. It's all over the Constitution in many, many, many places. Life, liberty, and the pursuit of happiness being the basic one. But if you look at the Constitution, it is full of protections, as are the individual statutory enactments in various realms. The big one right now, of course, is protection of individual data. And that's being looked at differently all over the world. It's a relatively new phenomenon because of the relatively new state of the internet. And all the countries are going to have to level off at where it makes sense to find the right balance. I don't think any of the countries, including this one, have necessarily figured out exactly what should be private, what shouldn't be private. But we're all struggling towards some kind of a norm. That norm isn't going to be the same in every country, and that's, in my view at least, okay.
President Beinisch.
Well, I agree that we are going through changes in society, which of course influence our different attitude also in the legal field, which sometimes develops slower and sometimes quicker. But the main thing is that you cannot disconnect the values that we give more weight to and more importance from our history, from our background, from our culture. And I think dignity is a good example. I mean, we have in our basic law dignity, the value of dignity. We interpret it differently than the German system. Because in Germany, if I dare to speak about Germany, in Germany it's an absolute right, which naturally, when a court interprets an absolute right, it interprets it narrow, because it gives no discretion to the court if it's a right to dignity. In our system, it's the opposite, because we don't have, many of rights are not enshrined in our basic law, which means there is no statutory constitutional right written for equality, for freedom of expression, and other rights. So what did the court do? We said that the autonomy of the person, which is dignity, includes freedom of expression, it includes equality, it includes much more rights than are expressly put in the basic law. But dignity in our system is not an absolute right. all the rights in our basic laws are relative, which means this gives the court kind of power to balance. Now, there is no hierarchy in rights, this is true. But if we have to put an hierarchy, I think we could conclude that the right to life is the most important right. And the importance of dignity, especially in the German culture, not only that it can't, I think it's one of the lessons of World War II and what happened there. So dignity was really the most important thing to achieve. I think it is really the most important thing, but you have to wait with other rights. As I said, the right to life, you cannot say this is not maybe the most important. So sometimes you combine, as they said, as to right of a fetus, to life, which part of the dignity and all this kind of jurisprudence. But this is a very good example to the different background that develops a different system of interpretation of what looks like the same rights.
Thank you very much. You know, we are jurists, so despite the fact that this is the beginning of the very interesting conversation, we have to do justice to the speakers of the next sessions. So we have to conclude here. Thank you very much for being